Hi everyone, my name is Yasmin Abdelhak Barker. I'm an attorney here at SQ Law practicing family law. Let's talk child support. Now, if you and the parent of your child already have an existing child support order, whether that came through an old divorce case or an old paternity case, and somebody is seeking a modification or a change in that child support amount, you might be asking yourself, what does that entail? What do I need to show? What do they need to show? What does the court need to know? And there's two situations in which a modification of child support is warranted, or at least under the statute, there are two situations that it's appropriate to file for a modification of child support. If it's been less than 1 year from the last order, or I should say the current order, from the time that was entered, you're going to have to show that there's been an extreme change in the circumstances which renders the current child support order as unreasonable. And that can include situations, for example, if you are severely injured and your job requires a lot of physical labor, let's say, and that's the career path that you've done pretty much all of your working life, and now you're all of a sudden out of that career option. That might warrant a modification even within that 365-day period. So that's really only reserved for those unexpected, out of your control situations. That does not mean if you quit your job, you can file for a modification of child support. But if you were laid off and you've been searching and searching and searching for a similarly paying job or career opportunity, you may have a claim, and I say may because it's very case by case, fact by fact, the analysis goes by. So that's if it's been less than 1 year. Now, if it's been more than 1 year, which I think is probably a little bit more common, you're just gonna need to show that a new calculation would differ by at least 20% from what the current calculation says. So you might be familiar with what I'm talking about when I say calculation. We work with a child support calculator that considers the income of both parents, if there are any work-related child care costs on a weekly basis, whoever is paying for the health insurance premiums of the children or the child and what those costs are on a weekly basis, and the number of overnights that each parent is exercising in a given calendar year. We plug that in, and sometimes there's a little bit of other information that we include. We plug all that into the calculator, and it tells us what is the presumptive child support amount, meaning what does the calculator believe is an appropriate child support amount. If we run a new calculation based on today's numbers, and that amount differs by 20% in either direction, then a modification of child support may be appropriate. And I do want to say that doesn't necessarily mean that you or your co-parent has received a 20% increase or decrease in income. It means if the calculation itself differs by 20%, then that might be where it's appropriate. And as with anything, in order to get that modification, you file a petition, you go through the court process, and you see how that plays out for you. And if you'd like help with that, or if you have any other questions, you can give us a call at SQ Law, or you can check our blog, website, or other videos that we have up for you.